Hi, Equals. It's Kim. Today I want to talk a little bit about Title VII because there's a couple of cases and lawsuits that are moving their way to or are at the U.S. Supreme Court, which, by the way, goes by the acronym SCOTUS, SCOTUS, Supreme Court of the United States, because we do a lot of acronyms on this vlog. Anyway, SCOTUS in the fall is going to be hearing a couple of Title VII cases, and there's also some others that are moving through courts that you might have heard about in the news recently. And essentially, the question, Title VII question, is, does the word sex in the 1964 Civil Rights Law include and cover sexual orientation and gender identity? You would not believe the number of people I run into who have been taught, so it's not necessarily their fault, who have been taught that discrimination is illegal. No. The U.S. Civil Rights Code says discrimination is illegal in housing, public accommodation, and employment. And just also like things like school and credit and that kind of thing. They fit under those, sort of. Anyway, but there's other laws that cover them. But anyway, those things are illegal if the reason you were discriminated against was because of your race, your religion, your national origin, or your sex. That's the 1964 Civil Rights Code. Only those four things. And it just happens to be that in 1964, at the very last minute, some legislators threw in sex, actually in an effort to kill it. They couldn't imagine that legislators would actually vote to support that. And they thought it would kill the bill. It passed. So race, religion, national origin, and sex. Well, because they threw sex in at the very last minute, there's no legislative conversation leading up to the passage of the law that would say what they meant by that. Were they talking just about man and woman, or are they talking about some of these finer points like gender identity and sexual orientation? Because you can make a sex argument that if, so looking at me, all right, that if I went into my employer and said, I want to be called John, and I want you to use he, him, his pronouns, and then you fire me because I am transgender, then the argument kind of goes, and this is oversimplification, but goes that if I were a man asking to be called John and to have he, him, his pronouns used, or if I was assigned male at birth and asking to be called John and have my pronouns be he and him, the employer would not have a problem. The problem they have is that because my birth certificate says F, or female, and I'm asking to be called John and to use he, him, his pronouns, that I've been fired. So the argument is that it's that sex marker on my birth certificate that is the problem. So it is sex. That's the legal argument here. Now, same thing with sexual orientation. If I am dating a woman and I get fired because my employer finds out that I'm dating a woman, but if my sex assigned at birth were male and I was dating that same woman, there wouldn't be a problem. But because my birth certificate or my sex assigned at birth is female and I'm dating a woman, this employer has a problem with it. And so it boils down to, what is the sex marker on my birth certificate? So it's sex. That's the legal argument, essentially. The U.S. Supreme Court, SCOTUS, has yet to rule on whether this is a legitimate argument or not. And so some people may oppose this idea because they want the law to actually say sexual orientation and gender identity, and there is a bill at the federal level that would do that. There's one here in Ohio that would do that in Ohio's law, because Ohio has the same problem. So that's Title VII, and we call these Title VII cases, and the question is, does sex cover gender identity and sexual orientation discrimination cases? So if somebody is discriminated against in their work, so John is fired by his employer when he indicates that he's transgender, he can file with the Equal Employment Opportunities Commission, which is a federal commission, and say, I was discriminated against under Title VII based on my sex. And take that, and then have that argument, have that discussion with the EEOC, whatever process they go through, and then the EEOC generally gives a letter or kind of like permission for you now that there's no other way to solve this situation, and you have a relatively good case in their mind, and they give you a letter that gives you permission to take that case to court. So then you go to court. You have to be able to afford a lawyer. You have to be in a position where having the press know and put in, have your story told in newspapers and stuff is okay for you. Some people don't, and so would never do this. They can't afford a lawyer. They don't know they have these options. There's all kinds of reasons people don't bring these cases. And even if you go to court, because there's no clarity around whether sex in Title VII, or the 1964 Civil Rights Act, whether that word sex actually covers gender identity or sexual orientation, you may or may not win in court. People are winning often enough that there is discrepancy in the various courts. One court says one thing, another court says another thing. And so when that happens is usually when SCOTUS, or the Supreme Court, U.S. Supreme Court, decides, well, okay, we'll hear this case and try to settle the issue. They've had opportunity before. They could have done this in the Lawrence case in 2004. They could have done this in the Obergefell case in 2015. They chose not to. They could have even done this in the Masterpiece case decision, which was, 2 years ago, 2017. So they've had all these opportunities to do it, and they haven't. So here they are, back again with Title VII cases in front of them. So that's my little primer on Title VII, and why these cases in October are important is to find out whether that will be the avenue through which LGBTQ people finally get protection from discrimination in employment, public accommodation, and housing. If this doesn't work, it's not the end of the world. Then we go back to the same work that we did before, which would be to add sexual orientation and gender identity, specifically those words, to the list. So in the example of Title VII, instead of just saying race, religion, national origin, and sex, it would say race, religion, national origin, sex, sexual orientation, and gender identity. Now, for some of you, do know that there are separate laws that cover disability and marital status and some of these, and military status, veteran status. Those are actually covered by different laws. And sexual orientation and gender identity, another thing is it could get its own law and not be part of the 1964 Civil Rights Act. Who knows? But we would just have to go back to that strategy. So yeah, it'll be interesting to find out in October what SCOTUS decides to do, because they could punt again, which they've done in the past. I think it'll be harder this time for them to punt. But who knows? Here's to waiting to find out. If you like my videos, please give me a thumbs up, hit the red subscribe button, hit the little bell to be notified every time I put up a new video. Have a great week, equals. Bye.